Okay, we'll take it up after some time.
Lordship, please.
Mr. Mozu, you are there for the, what do you call this? Accountant General?
Yes, Lord.
Yesterday there was a matter pertaining to a person concerned. Anyways, I fixed it on 1/9
Okay.
because your name have not been reflected.
Yes.
Because the respondent number 4 and 5 were subsequently included.
Lordship.
And I've asked them to show the name.
Lordship. No, in fact, Lordship, when the cases are filed, we have made a request to the registry that notice should be served to us if AG is the party. Many times the cases are filed and then the notice is not served.
No. That is not the case because here initially there were three parties.
Lordship.
This accountant general was not a party.
Not a party. Okay.
So subsequently was made a party.
Okay. If that's the case, Lordship, yes, I do. Obligation.
For admission, item number 3.
What is this?
This Lordship. Lordship, in this case, the petitioner, while serving this way and his job on a regular basis, was removed from service by an order dated 21st September 2023 on the ground that the petitioner possesses a fake educational documents and also convicted in a criminal case under section 352, 354 the IPC and sentenced to 3 years of imprisonment by judgment dated 19/5/2023.
So you were terminated
Yes, Your Honor.
by applying the exception 2, Roman 2 of Rule 11 of the 67 rules.
Lordship.
It appears so from your prayer. Now, that must be on the basis of some fraudulent documents.
Lordship.
Now, those fraudulent documents happens to be, as per you, not properly looked into. But you have been convicted
Lordship.
by way of, in respect to a particular offense
Lordship.
of forgery of documents. Is it? Are you convicted or not?
Yes, Lord, convicted, but in different criminal case.
In a different criminal case.
Lordship.
But if you are convicted in a criminal case by virtue of the provision of section Rule 11, are you not to be dismissed from service? Let us not go what Miss Mary would say, but just give, isn't this the fundamental of Rule 11? Let's read Rule 11 of the 67 rules. Where is Rule 11? Got it. You have not put the entire Rule 11. Look. The entire case is based upon Rule 11, and you have not brought the Rule 11. Isn't it, Miss Mary? Where do I find Rule 11? Where a penalty is imposed on a government on the ground of conduct and which has led to conviction in a criminal case. So, once you are convicted in a criminal offense,
Lordship.
unless you set aside the conviction, Rule 11 will apply.
Yes. But Lordship, here the trial court was able to give the benefit of under section 4 of Prohibition of Offenders Act for a period of 2 years. And in similar situated cases, the Supreme Court and the High Court in several cases, even if it is convicted, it automatically does not terminate the service.
No, here it's a case that normally there should be an inquiry. Now,
That's Lordship.
irrespective of an inquiry, in view of Rule 11(1), a person can be dismissed from service if he is convicted of an offence. Isn't it? Where a penalty is imposed on a government servant on the ground of conduct which has led to his conviction in a criminal charge. So what happened to that? Yes, you went to jail
That's Lord.
and
That's Lordship.
period over.
The trial court has given the benefit of the benefit under Section 4 of Probation of Offenders Act for a period of 2 years.
Then
And I'm still in probation, Your Lordship. The concerned department has already forwarded that I have also cooperated, and it is served a letter to the honorable court.
let us see where it is. Reinstatement. Where is your conviction order?
Lordship, it is in page 40.
So offense under 354D.
Lordship, may kindly prepare page number 72. Just a minute.
But tell me, you were an ad hoc teacher. Huh?
Sorry, Lordship.
Were you an ad hoc teacher?
Yes, Lordship.
Whether the rules of 67 will at all apply, madam? Ad hoc teacher?
At all.
Huh? Whether the rules of 67 will apply?
60. Yes, yes,
Would it apply?
yes, yes.
Why? This is
Basically,
only for
appeals-
those people who
Your
are in the
Lordship,
government
here-
service.
Yes, Your Lordship, Your Lordship. Here, the issue is that the petitioner has obtained employment.
Government
within-
servant means a person who is a member of a service and who holds a civil post in connection with the affairs of the state and includes a person whose services are temporarily placed at his disposal. So therefore he comes up.
Yes, yes.
Hmm. So no case. Bad case. And you are to prove, how do you prove it? They found that your documents are forged.
Yes. We are on that.
Lordship, to specify this on a report, here the respondent authority
Yeah.
did not call for the original documents and they simply referred to the
What are the documents which are forged as per you, madam?
Your Lordship.
However, the answer does not acknowledge except like any of the area which is inconsistent. Which are the documents which are forged?
Your Lordship, if Your Lordship would see the judgment
See
on
the
the
verification report from AR from Rashtriya Bharsha Remand. In response to the report indicated that the admit card and mark sheet equivalent to class 10 for so and so was deemed fraud, fake. Consequently, department sought further verification of the petitioner personal documents from Rashtriya so and so, from where the documents were originally issued. In response, the so and so, through a letter later confirmed that the petitioner's AR were genuine and authentic. It may be mentioned that so and so affiliated AR man. Madam, kindly come to page 5 of your affidavit.
Yes,
of
yes,
petition.
yes. Your
The
Lordship.
second paragraph.
Yes.
On so and so, the petitioner again submitted 2 letters addressing the inquiry report of so and so and use of the 2 different signatures of the principal regard. Regarding the second letter dated so and so, it is important to state the petitioner has deliberately tried to mislead the department by claiming that he only became aware of his fake so and so during the personal hearing. On what basis do you say this?
2 letter has been received from
So-
the principal.
From which?
The first letter declares that his certificate is genuine, whereas in the second, after the inquiry was conducted, the second letter shows that due to oversight, the principal has written the first letter, so he had written an apology letter also.
With due respect
So-
and humbly, I was convicted and released on probation. As per the Honorable Court's direction, I have the right of preferring an appeal to the higher court against the judgment and order. Therefore, I will. You did not file an appeal against that order of 19/5/2023?
No.
no Lordship.
And the problem arises.
But then it was only on the paper. I was not being terminated.
That is the biggest problem. No, 19.5 of the POSCO judge.
Oh,
You didn't file an appeal.
Rachid, I was preparing, but since was of the financial constraint, I couldn't go ahead.
You
with
should
it.
have approached the legal service authority. But the problem arises because of this.
This
I still
project.
remember one case where I could not interfere. In fact, a person concerned was convicted and an appeal thereagainst was filed. In the meantime, while the appeal was taken up, this person concerned had already served his sentence. So the appeal law otherwise became infructuous because he had already served. And I still remember the matter came up before Justice Angami. And Justice Angami said that as it has happened, so nothing remains. Criminal appeal closed. Conviction remains. And because of that conviction, he didn't get a pension. Because when there is a conviction, you cannot get a pension in view of the pension rules. So, that case,
Rachid, I may be given time for the appeal.
you are always at liberty to file an appeal. Who has asked you not to file an appeal? You should have filed an appeal. But with that conviction, maybe under the you have what has happened? Conviction is there, but in the sentence, you are given certain benefit.
Yes, Rachid.
That this is your first offense, there's a family, so instead of that, you will be under probation. That's it. There's a sentence, but the conviction remains. And with your conviction, therefore, you come within the ambit of 11. Big problem for you. Apart from that fake document. Now, I'm asking you where 19.6, no? Yeah. This document at page 40. With due respect and humble submission, I have the honor to state that I came to know only on Iman as I was called for hearing by the concerned authority in the air that my Hindi are fake. I request your estimator to re-verify the two signatures of the principal Iman, which was purported by the department in Iman. I was not informed at that point of time. Report. This is the report. This is a very dangerous thing, page 41 of the affidavit. The first thing in the morning, I have to dismiss a petition. At least that registry is the thought of issuing a motion before that. Now the fear of the other councils also. The day starts, how the day starts. Chalo, let us dismiss. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss So-and-so appears on behalf of the respondents' numbers 1 to 4. The petitioner herein is aggrieved by the dismissal from his service, is aggrieved by the not even challenge that order.
I've not even watching about that was denied.
Where is that order by which you are dismissed from service? Is aggrieved by the dismissal of the petitioner by the order dated 21/9/2023. As well as the rejection of the appeal filed thereafter. Full stop. The petitioner also have sought for a direction that a fresh inquiry be held pertaining to the authenticity of the petitioner's educational documents. The question as to whether, next paragraph, as to whether the petitioner's case, the case set up by the petitioner merits consideration. The same can only be seen from the perusal of the facts which led to the filing of the instant writ petition and the respective pleadings exchanged between the parties. It is next. The case of the petition, as it would be seen from the perusal of the writ petition, that by an order dated 6/6/2002, the petitioner was initially appointed as ad hoc Hindi teacher under the establishment of the Directorate of School Education, Nagaland. Subsequent thereto, the petitioner's services were terminated by an order dated 4/6/2007. However, subsequently on 27/8/2008, the petitioner was again reinstated. The petitioner thereupon filed a writ petition, which was registered and numbered as WPC number 194K/2012. Seeking regularization of his services. However, this court, by an order dated 5/9/2013, dismissed the said writ petition. Without prejudice to the petitioner, to obtain further clarification or certificate from an affiliated college university and submit the same to the education department. This court further observed that in the eventuality genuine documents are submitted, the case of the petitioner be considered in terms with the office memorandum dated 23/8/2007. While the said writ petition was pending, the Directorate of School Education had sought for certain verification in respect to the documents submitted by the petitioner from the principal Rashtriya Bhasha Hindi Training Institute, Hindi Nagar, Padam Pukuri, Dimapur. On 22/5/2012, the principal, Rashtra Bhasha Hindi Training Institute, gave a report that the petitioner was a student of the said institute and passed his Porishoy examination in the year 1997. It is the further case of the petitioner that on 5/2/2014, the principal of RB Hind School also issued another certificate stating that the petitioner was a private student of the institution and had passed the Pariksha examination as a private candidate in February 1997 in 3rd Division, bearing roll number 1431, conducted by the Rashtriya Bhasha Parisar Samiti, Wardha, Maharashtra. The petitioner, on the basis of those documents, submitted before the respondent authorities seeking regularization. Subsequent thereto, the respondent number 3, by an order dated 2014, appointed 2 officers of the department as enquiry officers to physically verify the genuineness of the petitioner's documents and to clarify as to how the letter dated 25/1/2012 issued by the principal RBHTI Dimapur and a letter dated 11/8/2009 issued by RBPS Hindinagar Wardha are contradictory to each other. Pursuant to the said inquiry being conducted, the respondent number 4 submitted a written reply on 18/8/2014 stating that upon verification and proper scrutiny of records, it was found that the petitioner was never a student of the institute and sought for withdrawal of the letter dated 22/5/2012 and the same be treated as cancelled. On the basis thereof, the inquiry committee submitted a report on 11/9/2014 stating inter alia that the Hindi-related educational documents so submitted by the petitioner were fake. Next. In the meantime, while these inquiry proceedings were going on, a criminal proceedings was instituted against the petitioner and a charge sheet was submitted being Thonoknyu, THONOKNYU, PS case number 1/2022. Under section 354/354A of the Indian Penal Code, read with section 8/9 of the prevention of, what is, put the full name, POXO, full the. In view of the criminal proceedings initiated against the petitioner, and the petitioner was arrested and kept in custody for a period of more than 48 hours, the petitioner was suspended. It is also relevant to take note of that by an order dated 19/5/2023, the petitioner was convicted under section 352/354 D, capital D, of the Indian Penal Code by the learned trial court, by the learned court of the special judge, POXO. Kohima, madam?
Your twin son.
Huh?
Twin son.
Twin son.
Yes.
However, applying the provisions of Section 4 of the Probation of Offenders Act.
Page 70.
The petitioner was released on probation for a period of 2 years. Subsequent thereto, on 8/6/2023, the petitioner was given an opportunity of personal hearing before the competent authority. Pursuant thereto, by the memorandum dated 8/6/2023, the petitioner was given an opportunity of personal hearing before the competent authority on 16/6/2023, and to explain the circumstances as to why penalty should not be imposed upon him in terms with the Netherlands Service Discipline and Appeal Rules 1967 for short the rules of 1967. The petitioner appeared and submitted his written statement of defense, and in pursuance subsequent thereto, the impugned order dated 21/9/2023 was passed, whereby the petitioner was removed from service in terms with Rule 11 of the rules of 1967 on the ground that the petitioner was the communication. The petitioner was
Page 80.
petitioner was culpable of furnishing counterfeit educational documents to secure his appointment, and he was also convicted of criminal charges under Section 352/354D Indian Penal Code. The petitioner thereupon filed an appeal, which did not meet, which was, however, dismissed. It is under such circumstances the petitioner has approached this court, seeking the various directions, seeking appropriate directions for setting aside the order of dismissal from service dated 21/9/2023, as well as all consequential orders, and further seeking an inquiry in respect to the educational documents of the petitioner. The record reveals that pursuant to the writ petition being filed, this court issued notice on 9/9/2024. The respondents have filed a detailed affidavit on 12/12/2024. In the same affidavit in opposition, it was stated that the petitioner, in order to obtain his appointment, had submitted fake educational documents. It was also stated that the petitioner, via a communication dated 9/6/2023, had duly admitted that he became aware that the documents were fake during the personal hearing held on 16/6/2023. The report of the personal hearing held on 16/6/2023 have been enclosed as annexure Roman 10 to the said affidavit in opposition. In addition to that, the respondents have duly supported the order of dismissal from service dated 21/9/2023 on the ground that the petitioner was convicted of criminal charges. First, the petitioner thereupon filed an affidavit in opposition, reiterating the statements made in the writ petition and denying to the contents of the affidavit in opposition. First. Next. In the backdrop of the above, this court heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Ms. So-and-so, the learned counsel appearing on behalf of the respondents, whose submissions were identical, were as stated in their respective pleadings. And for the sake of brevity, this court is not repeating the same. First, next. During the course of the hearing, this court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner herein had preferred any appeal against the order of conviction dated order of conviction under section 352 and 354D of the IPC dated 15/5/2023. The learned counsel appearing on behalf of the petitioner submits that to his information no such appeal have been preferred. In the backdrop of the above, let this court let this court take into consideration as to whether the petitioner has been able to make out a case for interference and for issuance of the or granting the reliefs as have been sought for by the petitioner. The materials on record show that the petitioner was appointed on 6th of June 2002 as an ad hoc teacher appointed on ad hoc basis as Hindi teacher at St. David School, Pasovia in a scale of pay. The petitioner sought for regularization of his services. But however, on account of there being contradictory documents as observed by the learned coordinated bench of this court in its order dated 5/9/2013 in WPC number 194K/2012, the petitioner's request for passing appropriate directions for regularization of the petitioner's service was declined. The petitioner was given an opportunity to provide clarification or oblique certificate from an affiliated college or a university, and the same be submitted to the education department. The petitioner laid emphasis on the certificate given by the principal Rashtriya Bhasha Hindi Training Institute by letter dated 21/5/2012. And submitted the same certificate again, laying his claim for regularization. But the materials on record categorically show that on 18/8/2014, the certificate on the basis of which the petitioner claims his rights that is the letter dated 21/5/2012 was withdrawn. And it was categorically mentioned in the communication dated 18/8/2014 that the petitioner was never a student of RB Hindis College, and it was specifically mentioned that the communication dated 21/5/2012 was issued without proper verification. This is a finding of fact arrived at by the inquiry committee, as would appear from Annexure Roman 10 of the affidavit in opposition. First, this court finds it very pertinent herein to observe that the jurisdiction which this court would be exercising in reference to the order of dismissal of service dated 21/9/2023, as well as the inquiry report dated and the inquiry report dated 26/6/2023, Annexure 10 to the affidavit in opposition, is an exercise of jurisdiction to issue a writ in the nature of certiorari. First, the Supreme Court in the case of Central Council of Research versus Bickerton Das, reported in 2023 16 SCC, you just ask them, they will give it to you. Had categorically observed the contours of the jurisdiction of the court while exercising the writ in the nature of sorcery. The Supreme Court observed that the court exercising the jurisdiction would only look into the decision-making process and as to whether the said decision-making process and the said jurisdiction can only be exercised if the decision-making process is of such a nature which is palpably erroneous or suffers from perversity or is without jurisdiction. Else, the court would refrain from exercising the jurisdiction. Paragraph 48 to paragraph 50 being relevant is reproduced herein under. First, next. This court further takes note of that the petitioner have been convicted of offences under section 352 and 354D of the Indian Penal Code. The conviction of the petitioner in a criminal proceedings can be an additional ground for dismissal of service as is mandated under Rule 11 of the Rules of 1967. Consequently, the reasons so assigned in the impugned order dated 21/9/2023 and the basis on which the said order has been passed, that is the inquiry report dated 26/6, what is that inquiry report?
2023.
26/6/2023, Annexure 10 to the affidavit in opposition, in the opinion of this court, does not merit for this court to exercise its jurisdiction under Article 226 of the Constitution. Consequently, this court does not find any merit for which the writ petition stands dismissed. However, in the facts of the case, this court is not inclined to impose cost. Yes, item number 1 and 2. Where is that counsel gone? Very difficult to find out.
Inadvertently, he was waiting for lordship in court number 3.
He must be thinking that I cannot sit here. Maybe that's the lead. Yes, tell me.
My apologies, Lordship. The Lordship, here there are two writ petitions, that is WBC 297 and 298. So read that 298 may be taken up first one because here all the evidence has been filed to Lordship. Here, Lordship, the petitioner was given an appointment on land ownership basis.
You got an appointment.
Yes.
Then
Now the private respondent number 6 to 17, that is the village authorities and the representative of all the clans, they passed a resolution stating that the land was given for a development of the community. So the land belongs to the community. So my land ownership certificate as well as my appointment is to be set aside. That was their resolution. And accordingly, the deputy commissioner canceled my land ownership certificate. So I filed a writ petition before this honorable court. So now this honorable court has given a direction to the deputy commissioner to hold an inquiry. Now the inquiry has been given my writ petition. Now the inquiry states that
where is that inquiry?
bench 63 relevant part
Which one? 298.
290 floor.
Page?
13, page 63, Lordship, my apology. Annexure 13, page 63.
In pursuance to the notification dated so and so on the Constitution of the inquiry on the land ownership basis, the committee had meeting with all the stakeholders of the area, so and so. article of school. To keep on sitting stays You belong to which clan?
Chakrunu clan,
Shakrunu.
Lordship.
You are donated by late Jebuo. Who is
Lordship, that's my grandfather.
Jebuo from so and so clan as acknowledged by the village council so and so and the family members of so and so. On the other hand, the original owner is Jebuo Chakru. Whereas the village council and clan leaders, excluding the donors, claim that the village elders during the they agreed to create a such the village ground panchayat hall that's owned by way of donating the land. Whoever has land and contributing money, such the present land when the jail stands in town, the agreement against it. But where out here,
Lordship.
Mr. Mozu, where in this report
Lordship.
there is a mention that there is other persons who have donated the land?
Lordship, can we come to page number 2?
Yes, where is it?
The village elders during the late 1990s had unanimously agreed to create a community. So the
No. That is a different thing.
Lordship,
They have agreed to create a community.
Lord,
And for that, this land will be given to the community.
yes,
Another aspect. But the fact that the land actually belongs to is a finding of fact that the grandfather of the petitioner had submitted the land. The finding of fact.
yes. Now the fact remains that, Lordship, we are not disputing that. But the fact remains, Lordship, this land is not only a portion of the land. The land donated by the clans, different clans.
No, there is no mention. Paragraph 1 says that it has only been given by late Jebuo.
Lordship, the decision of the single bench in the earlier petition was to ascertain the land of the petition.
Understood, but this is the finding of fact arrived at.
Yes,
Now, if this is the basis on which you are saying that he is not entitled to,
yes. Lordship,
then how do you take care of paragraph 1? I would have understood that this land, 4-5 persons have donated together.
no,
It's not what has been stated. It's a finding of fact arrived at serial number 1.
yes.
That the land originally belonged to the grandfather of the petitioner.
That is not disputed, Lordship.
So therefore, the question is whether he gave the land for community or not. Now,
Lordship,
is it the case of the deputy commissioner, or is it the case of the school anywhere that the land was donated to them by the village? My
Lordship,
question is that.
yes. Now, Lordship, can you come to my affidavit? I have placed on record because this has been concealed by the petitioner in filing the petition. Page 12 of my affidavit in opposition.
Of this petition,
Yes,
298,
yes.
page
The
12.
whole
Respond
fact-
number 3. Respond number 3.
Lordship, respondent number 6 to 16.
6 to. Who are you?
We are the.
You are not
Class-
government.
No, Lordship. We have been implemented as a party.
Then I think you should fight it out. You have been included in the party, you should fight it out somewhere. And how are you concerned? Somebody gets a job, you are not going to get the job. Are you
No,
going to get the job?
Lordship, there was a resolution of the village. that
I will
everybody
no,
has-
Mr. Moju, I will hear you later. First, let me hear the
Yes.
government. Let the government explain how, on the basis of 17/6/2023, this happened.
Your Lordship, this verification report was done after calling all the stakeholders to Lordship.
Understood.
Yes.
But where is the finding that the village council handed over? And where is the finding that he handed over? The grandfather handed over to the village council, the village council handed over. Then only it will be a community. But if the person has handed over, the grandfather had handed over, which is the fact that the grandfather is the owner of the property. There's no quarrel. Serial number 1 says that the grandfather of the petitioner is the owner of the property. Now, therefore, it is now you are fighting against 1 against 16, isn't it? Because of the 4. Now, the fact, I don't understand what the 6 to 16 have to do. If he gets the job, because the 6 to 16 cannot get a job if they claim it to be a community land, unless they say that this particular job should be given for open advertisement. I think that must be their case. That he has been appointed. How many years you have been running?
Lordship, I was appointed on 2017 September.
Long time. You
As
should-
per the order, last order in the writ petition, a direction was given that as per the finding of this application, if the petitioner there is not the landowner, then his appointment should be terminated.
No, the question is
Now-
there is no denial that the grandfather was the landowner.
Yes, the original landowner.
So then,
But subsequently, as per the consensus agreement between the villagers,
where is the agreement? First of all, it is not the agreement. Did the village council hand over the land to you? That is the question. Or did they hand over the land? If we take what you are saying, then in all cases, there cannot be a land ownership employment. Because everybody is giving the job, land initially. See paragraph 3A of that 16.8. Read it. Yes, Mr. Council, you should read it when I am arguing on your behalf. 16.8 2025, the 18, that office memorandum. Read paragraph 3 or 2 maybe. 3A.
Lordship, I have not enclosed that particular office memorandum, Lordship, in my petition. That regarding that office memorandum.
Yesterday there was a matter where a council argued that not enclosing of the office memorandum
Lordship.
would amount to suppression of material facts.
Lordship, in
How
my,
do you take care of that situation then?
Lordship, I have enclosed one,
I've signed the order, it's a different thing. I rejected his submission.
Lordship.
But then also, that is that different case, this is a different case.
Lordship, if I may, Lordship, my annexure 17, page 71. This is a letter written by the Undersecretary School Education, Your Lordship, page 71.
Yes.
Dated 5th August 1991, point number 5, Lordship. Grade 4 post, direct appointment should be made by the appointing authorities from among the landowners whose ownership of land is certified by the village education committee and local administrative officers, Lordship. This particular document was holding the field, Lordship.
Now, the fact that the land was handed over is not in dispute.
Lordship.
But another aspect arises because, but your appointment was in 2017.
Lordship.
So this comes before the 2018 thing.
yes.
So therefore, the verification which is required to be done by the deputy commissioner doesn't have any relevance. How do you take care of that situation? The regulation has been done in respect to land ownership.
5th March 2008,
Huh?
the notification of the land review form.
That is 16/8/2018.
16, but before that, there's a 5th. Because 5th March has been reiterated on August.
Where is the 5th March?
5th March, Lordship, we don't have here with us. But at clause 3B, it says, prior to 2005, any that land has been donated, the commissioner has to verify the actual land owner.
No, verify it's a landowner, but Why have you moved this matter on 2023? You see, he has moved the matter on 2023.
Lord,
The order was passed in the year 17/6/2023.
Lord.
You initiated action when?
On 17/6.
17/6 is the year, the formation of a committee.
The inquiry report was done, verification report.
Oh,
was
they
done.
filed a writ petition in 2018.
Yes.
You filed initially a writ petition, na?
Yes,
2018.
yes. Now, Lordship, the post, I'm not claiming over the post, Lordship, but the post file began on the demise of my father. The first writ petition I filed, seeking appointment on compassionate ground. The petitioner hearing Lordship, he has filed, he was appointed against the post basing on the land ownership certificate issued by the Deputy Commissioner,
Hmm.
Kohima.
Hmm.
Without ascertaining the fact that he is a landowner, Lordship, who is the actual landowner, the Deputy Commissioner has issued that land ownership certificate. Later, it was found that the Deputy Commissioner, after later, they did an inquiry and they cancelled the land ownership certificate. So, in that previous writ petition, a direction was given to consider my case on land ownership, Lordship. Without mentioning that I should be appointed against the post which my father holds. My case was not considered, Lordship. That was a closed chapter. As per the term, I'll wait for my appointment as and when the vacancy arises.
But
No.
Mr. Modi, fact remains, the findings which is arrived at on 17/6/2023,
Lordship.
that the petitioner's grandfather was the owner of the land.
He is not disputed, Lordship. It's not only him, he has donated, Lordship.
No, that is the him who is donated. That is 70. Kindly compare it to 63.
63.
3.
Yes. Now, Lordship, in the WC number 297, Lordship, the petitioner number 3, who is the descendant of late Jebu, Lordship.
So here at page 11 of the affidavit filed by the respondent numbers 1 to 4, 5 in 298, there's a clarification given that sought for an inquiry report dated is clarified that GMS school Simirima was constructed on village community land reserved for development of village by the village authority. But the court did not interfere earlier in his appointment.
Lordship, the court has said after verification, if he's not a landowner, the matter ends there, Lordship. That's the last court order. Lordship, may kindly come to the judgment of this court. Paragraph 20, 1920. The Deputy Commissioner, shall I read, Lordship? The Deputy Commissioner Kohima shall accordingly make a detailed inquiry on the ownership of the land where the GMS Chatham is located with the participation of all the stakeholders, including the petitioner, the village authorities, and the clan who have donated the land for the school. On the completion of the inquiry, the Deputy Commissioner Kohima shall submit its finding to the Government of Nagaland, Department of School Education. This exercise should be carried within a period of 90 days. In the event that the Commissioner comes to definite finding that the respondent number 4 is not the rightful owner of the land, the government should take necessary step for terminating the appointment of the petitioner as carpenter helper. In spite of the inquiry report, Lordship, no action has been taken against the petitioner. Rather, he has filed his writ petition challenging the inquiry report. Lordship, another aspect of the matter.
Hmm.
Going by the own document of the petitioner, Lordship, at page 41 of the writ petition, Lordship, page 41. This is a resolution of the clan, different clans.
Yes.
Resolution passed on 3/7/2016. Lordship has found. Now, Lordship, the petitioner in writ petition number 297, serial number, petitioner number 2 and 3. Okay, can you see? Petitioner number 2 and 3. They are the signatories of this resolution.
Petition number?
2 and 3 in 297, in writ petition 297.
There are other. There's only one post.
Yes.
Why so many are there?
Lordship, they are all the children, the descendant of Shivu.
Okay.
Now, Lordship, this is a resolution. Lordship, I may be allowed to read the resolution. The members in the meeting resolved that all the 8 clans, it's not only one clan who has donated the land. 8 clans of the village has contributed equal share for the school and local ground. Therefore, it belongs to the village common property. The members resolved that the GMS plot belongs to every clan and every one of the village. In this regard, land ownership certificate cannot be issued to any particular clan or person. Now they are the signatories. Lordship, may kindly come to page 42.
So,
Serial
in
number.
spite of this, he was appointed on land ownership basis.
And a certificate not issued
Oh,
by
so it was cancelled.
it was cancelled by the deputy commissioner
No, by when was he appointed?
in 17.
But this is prior to that.
Lordship, that's the reason. That's the reason why we have come before the sample court.
No, where
It's
is
not
the appointment letter?
Page 70 of my petition.
Huh?
Annexure 16.
Page 70.
Lordship.
Yes, Mr. Council, how can you be appointed on land ownership basis if you are relying upon this particular document?
His land ownership has been cancelled. Certificate.
Because the resolution was of 3/7/2016.
16 years. And his uncles were the signatory. Serial number 10 and serial number 25.
297 is who has filed this?
The uncles.
The descendants of the
You are the
landowners,
same council.
Lordship.
And what do they say?
Praying for a direction that the commitment done by the then village authorities and the city authorities to be fulfilled. That is, cry for push to be given to the.
But the resolution says
Petitioners?
different.
No, Your Lordship, here in 2017, Your Lordship, the issue was between me and then the villagers in the rest of all the clans. So out of compulsion, I have to sign all the.
No, they
I have
cannot
to
take a
sign
stand.
here. That's why I impugned these particular documents in my earlier petition, Your Lordship.
Which one?
The
This
resolution.
resolution, Your Lordship.
Of 3/7/2016.
Lordship, okay.
Now, when there is a 3/7/2016,
Lordship.
was there any inquiry done in pursuant thereto?
Lordship, for that, I'll take you to page 37, annexure 5. Page 36 is the letter.
What is the finding?
Your Lordship, page 37, serial number 1, 2, and 3, Your Lordship. May I read, Your Lordship?
So and so voluntarily donated a portion of land for the establishment of a year without any binding or condition. During the year, so and so the contribution of, during the years from 76, the contribution of the clan's share, 8 clans towards the school was carried out in cash and in kind, and the collected cash was handed over to the then village authority. Assembly and representative 8 clans approached the landowner for more land adjacent to school building for construction of the toilet in exchange of yard. Landowner family denied, stating that till date no appointment was given, to which assembly members and representative of all clans promised to give chance privilege to them in case any great fall fell in the school. According, the landowner agreed upon and part away some portion of the land to the school for the second time in exchange of the land below. On so and so, villagers held a meeting and deliberated agenda so and so relating to demarcation of the compound. On Iman so and so, Iman C so and so expired. As a result, the post of carpentry vacant. On Iman, the department was forwarded with 4 applications applying for a post of so and so. On Iman, all the 8 clans so and so student union so and so held a meeting and resolved the results that all the clans have contributed equally so and so. Now, what is the finding? This finding was preceded by how did the deputy commissioner issue the land ownership certificate?
Lordship,
If this is the finding,
Lordship.
these are facts, how did the deputy commissioner issue the land ownership certificate?
Because, Your Lordship, this particular document was not properly looked into in the first petition. Instead, it was given direction to the deputy commissioner to inquire, Your Lordship. This particular fix was not properly looked into, Your Lordship. Now, in the earlier 1950, it is.
So,
If-
so prior to this,
No.
the deputy commissioner must have passed an order on the basis of these facts.
Lordship, that's why land ownership certificate was passed by the deputy commissioner on 23/11/2016, Your Lordship.
Where?
Page 34, annexure 2, Your Lordship.
34.
Annexure 2.
Ah.
Assets.
Now, this was challenged in some repetition. No.
Yes.
Lordship, after this, 3/7/2016 was passed, the resolution was passed. On the basis of that, again, my land ownership certificate was cancelled by the deputy commissioner, which is in annexure 9, page 42.
So, without looking into 3/7/2016, he issued the land ownership certificate.
Lordship, first of all, the land was transferred between me and the department only, not between the villagers, Your Lordship. In the inquiry report, they have stated in number 222, stating that in the 1970s, the land was given to the community. But which I have shown in the earlier inquiry, in the 1980s, all the village authorities, SMA members, and the representative of all the clan members, they've clearly stated that, saying that commitment has not been done. So resolution was made stating that grant proposal should be given when vacancy appears. That was not fulfilled. And then now my appointment is being given, Your Lordship. And then in 2016, now the present village authorities are coming up saying this and that, not
Mr.
honoring the.
Counsel, if
Yes.
this matter would have been the first time it had been before me, I am in your support.
Lordship.
But the problem arises because of the judgment of Justice Sema, wherein he says
Lordship.
that if he is not there, cancel his appointment. And a verification has been directed to be made. Now, this verification which has been made
Yes, Lordship.
is based upon certain further verification which was made on 17/6/2023.
Lordship.
And that is been clarified by another aspect,
Lordship.
that the land was jointly donated. This is on 25/4/2023, isn't it? 24, the last annexure of the affidavit. So therefore, don't you think that you need to go to the civil court then? How can this court look into this? As of now, these are findings of facts.
Lordship.
Problem, otherwise I would have said that, okay, he has been done there, it's okay. These are findings on which had not been done. But now they, on the basis of a direction passed by this court, a verification has been done. And this verification says that yes, the land was originally given, but it was given to the village community. And again, thereafter, another verification, another year has been given, and that has not been challenged by you.
Lordship.
You have not challenged this one, na? This last document. Have you challenged this one? Page 11 of the affidavit filed on 27th of February 2025. Annexure 3.
Respondent 6 to 17 affidavit, Lordship.
I don't know who has filed it. No, this affidavit has been filed by the government, I suppose. 1 to 5. See page 10 and 11. Isn't that a document which is very dangerous?
Lordship, prior to issuance of this office letter, the writ petition was pending, Your Lordship.
Understood.
Yes.
But in pursuance to a direction, they came up again with this.
Lordship.
How do I take care of it without a challenge to that? Don't you think that is a proper way for you to challenge this?
Yes, Lordship, for that, if liberty may be given, I may allow to withdraw it and refile part, Lordship.
You file another one.
Lordship.
You file another.
Yes, yes, that's
But
right.
unless you challenge this,
Lordship.
the problem is you have challenged 17.6. 17.6 has been clarified by this.
Lordship.
The 17.6 first paragraph, which is in your benefit,
Lordship.
is being diluted by this. I think you need to challenge this.
Lordship, I will.
Hmm. So you better take time today and say that you are going to challenge,
Lordship.
and I will allow you. Okay, make the submission.
Lordship, I may allow
And
to file a writ petition challenging the office letter 10 September
Mr.
2024.
So-and-so, the learned counsel appearing on behalf of the petitioner submits that during the pendency of the instant writ petition, an affidavit has been filed by the respondents, numbers 1 to 5, in WBC number 298K/2023 on 17th of February 2025, bringing on record a decision taken on a certification given explaining the contents of the inquiry report dated 17/6/2023. The learned counsel submitted that an order has to be tested on the basis of the said order which have been passed, and by way of this clarification, the respondents cannot further improve their case. This court, however, is of the opinion that if the petitioner wants to assail the communication, the petitioner has anything to say about the said communication, the petitioner has to assail the same. The learned counsel appearing on behalf of the petitioner submits that he would like to assail the communication dated 10/9/2024, as well as the clarification so given, which is Annexure 4 to the affidavit in opposition filed on 27th February 2025. So taking into account the above, the instant writ petition stands adjourned for a period of 4 weeks, granting the petitioner the liberty to file appropriate application to challenge the communication dated 10th of September 2024, as well as the clarification so given. If so advised.
Lordship.
For admission, item number 4.
Yes.
Let's do so. Lordship, in the present case, the petitioner is challenging the dispatch order from service. He was tried by the summary assembly court in on the charges of unauthorized absence from duty. Lordship, the unauthorized absence is occurred during the COVID-19 pandemic due to the national lockdown.
Hmm?
Due to the COVID-19 pandemic.
Where's the charge sheet?
Lordship, we come to page number 53.
Charge sheet.
Yes, Lordship.
Charge sheet will be before that. No.
The charge sheet. Initially, a tentative charge sheet was issued. Subsequently, they have issued the final
While
charge sheet.
serving in the field on so and so, having been granted 5 days earned leave with effect from so and so to so and so, failure to rejoin on demand and on expiry of the leave enjoined clear on 5th of October at quarantine center due with total absence. Okay. And then
Lordship, without going into the other aspects of the case, the main issue which I am asking the present read petition is, Lordship, the commandant, 23rd Assembly, he was the presenting officer in the track.
you are the
The commandant, 23rd Assembly, he was the presenting officer in the track. He passed the impugned dismissal order. Lordship, that is not permissible under section 11 of the Assembly Act 2006. That is one of the main issues. It's not a competent officer. The record of the proceeding starts from page number 59. And from this Lordship, page 59, it shows that the Colonel Vikas Saha is in command. He was the presenting officer.
where's the reply?
Lordship, the petitioner has not finally replied. It was a summary trial on this.
Then how do I interfere, mister?
Lordship, the similar issue it came up before this noble court. And this noble court inferred the order passed by the commandant on the ground that he has no jurisdiction. So
When you were asked, you said that you were guilty.
Lordship, I was made to say that I was guilty.
Hmm?
I was made to say I was guilty.
You were? You said that you were guilty.
Yes, Lordship, that was I was made to say. I was made to sign that documents.
No, you didn't submit a reply. You don't do anything.
Lordship,
Then how do you challenge it at a later stage?
Lordship, I'm challenging it on the ground that
You could write such a long letter, an appeal.
Lordship, I filed an appeal. That was
My overstaying. But tell me, did you see? I mean that while indulging as a driver under so and so, I went to leave for comment so and so, and came to Dimapur to pick up my children where I came. But also after coming to my movement with the village, which I could not resolve. And it was also into non-immediate food. I could not make contact with anyone, even however well conducted my unit, I will that, but won't have a word to you. Show me that you could not join till October. It is impossible. There was no such restrictions then. The restriction was till month of June, July. I could have very well taken it, but how about subsequent thereto?
Your Worship, the absence of.
You have not done anything. You see, Mr. Counsel, the problem is my hands are tied in view of
Worship,
various Supreme Court judgments.
Yes, Your Worship. Worship, I'm relying on just one judgment, which is reported in 2014, 3 GLD, page 2 to 8. Worship, a similar issue came up before this group. The Union of India went up on appeal of the apex court. The apex court dismissed the petition. The commandant is not a competent authority.
Huh?
The commandant is not a appropriate authority to pass a dismissal order under Section 11 of the Supreme Court Act 2006. Should be currently see page para 6. Earlier, the judgment was referred in this judgment, Worship.
So you say that you have been dismissed by
By an authority who is not competent to pass the dismissal order.
dismissal order. Where is that order?
Worship, we come to page number 70.
70.
70.
Colonel Commandant, what is this? So it can be by whom? As per rule?
Not below the article of the.
Where do I get the rules?
The rules is Act. 1611. 1611 block 2.
Now 11.2 says, an officer not below the rank of Deputy Inspector General may dismiss or remove from service any person under his command other than an officer or a subordinate officer of such rank or ranks as may be prescribed. Any such officer as mentioned in here may reduce to lower grade here, the exercise of power here. So you mean to say the commandant who is not of the rank of the Deputy Inspector General would not have done so.
Worship, in the provision of the clause 2 has been dealt with in this judgment. Para 5.
Where?
Para 5. The provision of the act is quoted in para 4. In the Tasmanian law quoted in para 5.
Here it says an officer not below the rank of Deputy Inspector General may dismiss.
It should
Not
be
below.
not below. It should be above the.
Above, the Deputy Inspector General may dismiss.
The commandant is admittedly commandant is below the rank of deputy inspector.
That's right.
So,
I will satisfy your lordship. If I will satisfy you, why the
Yes.
commandant has issued the order.
you satisfied?
After, right?
Oh. Yes, Mithun.
Yes, ordinary leadership under section 11, the commandant does not have the power. However, leadership in the summary proceedings. Also, the body down to as on Article Rules 57. Lordship. This is required to the summary proceeding. Summary proceeding. Power of the Assam Tribal Courts.
Power?
Power of the Assam Tribal Court in summary proceedings. Lordship.
Where?
Section 57.
Section?
57.
Hmm.
So under section 57, the commandant has a power to for C, 57 1C.
57?
Dismissal from service.
Punishment may be inflicted in
By
respect
commandant.
to offences committed by persons subject to this act and convicted by the Assam according to the scale. That is to say, death so and so, dismissal from service, compulsory requirement so and so. So this is being given by whom?
By the commandant brigadier.
Hmm?
By the commandant brigadier.
But this is given by awardable by the Assam Rifles Court.
Yes, Lordship, this is a summary court. Summary court, summary proceedings.
But
So, Lordship, there are three kinds of Assam Rifle Court.
Hmm.
Your Worship, if we see section 86,
Huh?
if we see section 86 of the act.
Section 86.
86. There are three kinds of Assam courts. In the present petitioner, he was tried by the summary assembly.
Kinds of General Rifles Court, Petty Assam Rifles Court, Summary Court.
The powers and functions, the powers of the summary assembly courts and section 96.
Then summary proceedings are usually held by the commandant. Lordship.
5 officers each of. How is summary, this thing a summary? The summary here may be held by the commandant
He is the presiding officer.
of any unit of the force and he alone shall constitute the court. That is 92(1). So therefore, his submission is, this is a power inflicted, it's a punishment inflicted by the under 57,
Yes, under summary proceedings.
by the summary Assam Rifles
My
Court.
lord.
And as such, it is within jurisdiction.
That is your submission. That is a submission of the of my referee. But if we see the Worship, section 96.
Subject to
powers of the summary as soon as possible.
may try any offense punishment. Where there is a grave reason for immediate action in reference can without detriment.
It's important to try any offense.
So the power is there
Section 4, subclause 4 says
of 96.
may pass any sentence which may be passed under this act, except the sentence of death or so. But subsection 1 and 3 says it is only empowered to try the offense.
Which one?
96, 1 and 3.
No, subject to the
Subject to the
provisions of
provision of
subsection
sub-
2, a summary may try any offense punishable
It's
under
only
this act.
empowered to try. Not
No, but
And if we
the
see-
power is given here for inflicting punishment under 57.
Yes, Lordship.
57 power punishment awardable by the Assam Rifles Court.
Lordship 57, it speaks about the 3 courts. There are three kinds of Assam Rifle courts.
Yes. So, but however, a petty Assam Rifles Court
And general Assam Rifle courts.
have no power, may try any offense where there is no grave reason for immediate action, and reference can, without detriment to the discipline, be made to the officer empowered to convene a petitioner for the trial of offender or so and so. A summary here may try any person subject to this act and under the command of the officer holding the court, except an officer or a subordinate officer. A summary may pass any sentence which may be passed under the, except the sentence of death or imprisonment for a term exceeding the limit specified in subsection 5. The limit specified in subsection 4 shall be 1 year if the officer has held either the post of a commandant or post here, 3 months in any other case. The counsel for the petitioner, you are arguing on the question of a disciplinary proceedings. He is arguing on the question of a punishment. There are two differences. If it is a case of disciplinary proceedings, 11 will come in. But if it is a case of a punishment being meted out under the act, it will come under the ambit of this, the
Okay.
57. There the problem.
Lordship, yes, Lordship, Lordship, that the meter released to disciplinary proceedings.
Hmm?
But the meter released to disciplinary proceedings.
Understood, but they didn't take it as a disciplinary proceeding. They have gone for the punishment. Now the punishment has been imposed upon you
By
by an Assam Rifles Court. By an Assam Rifles Court, kindly see therefore page 72. Any person subject to Assam Rifles Act who considers himself aggrieved by the finding of a sentence of the summary Assam Rifles Court may present a petition to the central government, the Director General of Assam Rifles, or any other superior in command of his officer who has held the summary, the Iman, provided that such superior officer has power not less than the sector officer. Here. You have been tried by the Assam Rifles and has been awarded the following sentence to be dismissed from service. And on the basis of that, you have accepted the jurisdiction and filed an appeal. Now, when you filed an appeal, the appeal got dismissed,
Yes, sir.
for which you are before this court. So therefore, the question of jurisdiction does not come into play. This is not an exercise under 11. This is an exercise omitted by the exercise done by the Assam Rifles Court.
Lordship, in case of a discipline or authority, the punishment has to be passed upon me by an authority who is committed.
I'm helping.
Lordship, the commandant, he was a presiding officer.
Huh?
The commandant, he was a presiding officer in my case. His report has to be submitted to the disciplinary authority.
No, no. There's no appeal there against. Where's the appellate provision?
Lordship, I submitted the appeal in under Rule 178 clause 3.
Mr. Lopa, kindly look into paragraph section 129 and 130. And 131.
Lordship, 129 and 130 speaks about the general assembly reports. The general assembly reports.
So kindly see 136. Finding and sentence of a summary assembly. Save as otherwise provided in subsection 2, the finding and sentence of a summary Assam Rifles Court shall not require to be confirmed, but may be carried out forthwith. If an officer holding the trial is of the rank of a deputy commandant or a rank declared in clause A of so and so as equivalent thereto or lower and has held rank for more than 5, he shall not, except on active duty, carry out any sentence and until it transmission of a. So therefore, it will.
It has to be approved, it has to be
Approved.
subject to approval by the.
No, it is not required. For in the instant case, taking into account 136(1. Now, 140 gives some more of a revisional power to the central government, the Director General, or any prescribed officer to annul the proceedings of the Assam Rifles Board on the ground that they are illegal or unjust.
Yes, please.
I'm looking into these so that if there is a mood, there can be something can be done in that regard. That is why I'm looking into it. Because the facts are otherwise very disturbing in respect that you have pleaded guilty. Nothing is there. You did not submit your written statement of defense. Nothing you have done. No witness has been brought in, neither you have produced anything. So they have stated in the affidavit that you have called up some officer for 2-3 days, then also you did not come. These are all findings which are there on affidavit. So for this court to do it becomes very difficult, and you know the scope is very less. So the only way it can be. One 139(1) gives a appellate power. 139(2)140 gives annulment of proceedings if it is unjust.
Just.
Bad case.
Lordship, this court in another proceedings by relying on the judgment passed in 2014. Lordship, I suppose another judgment, like so.
This won't come in. Because of the main problem is that this is a case not coming within the ambit of a disciplinary, but it's a case of punishment.
Your worship, in this case also, you will issue a show cause notice on the ground of misconduct.
Maybe it is, therefore, it's a case of disciplinary. It is a disciplinary proceeding, but this is a case of court, what do you call the petty officer, petty court.
Your Lordship, in the judgment that has been today, they have not discussed about section 87, but they have already relied on the section 11 that Commandant has no.
This is not a case coming within the ambit of that.
Yes, Your Lordship.
This is a case of punishment. Sure, I think we dictate.
Your worship, in that case, I have to challenge the action of the presiding officer on the ground that worship, it was a disciplinary board postings. Without coming to a finding that the offense committed by the petitioner. It was
Appellate authority has already dismissed the appeal.
no, worship, even though worship,
Appellate authority has given due reasons.
no, worship, the present punishment, it was imposed on the grounds of unauthorized absence. This is like disciplinary, in the disciplinary proceedings, the disciplinary authority has to prove that the alleged offense has been committed on the.
This is not a
The- the-
disciplinary
the-
proceeding. This is the proceedings under punishment has been imposed.
Worship,
That you have committed this. Now it is on the question of adjustment. So therefore, what I do is give you the liberty under 140. Go there. Go on the question of adjustment. That is the only way out. But this court can't look into this. On the question of jurisdiction, there is no case. That is the only way I can give you. Only way I can bring in that whether to consider as to regard the punishment. This court cannot touch that. It is a punishment of the authority. And 226 power is very limited. You see, this is a authority, this is as if it's like a tribunal. A tribunal has passed an order. This is not a disciplinary proceedings. There's a difference out there, no?
the presenting officer, he has to prove the charge that it was committed deliberately. That findings is not here.
You have asked that, you have asked for guilty, you have not even replied. How can I help you?
It was a summary trial.
Summary trial, you have been asked to reply, you are hereby informed that it is informed that you can depute a person. Nothing you have done. Nothing you have done. How can you help him?
Worship, in my written petition, worship, I have taken a ground up.
Kindly see here. Do you wish to make any statement? You are obliged, not obliged to say anything unless you wish. Accused declines to make a statement. So and so duly warned that. So and so demand that. On demand, the individual failed to rejoin duty on due date and absented himself without any. I waited for 48 hours, but he did not return, nor did he convey his intention to rejoin. I called him on completion of his leave, but he did not respond. Accordingly, so and so, copy of overstaying report attached to and so, an apprehension rule was so and so, on demand so and so, rejoined duty voluntarily. After absenting from here in connection, the accused declined to cross. To do. You see, the scope of this court's power is very limited. I can't help it. Chalo. Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner, Mr. Gauhati, the learned Central Government Standing Council.
No, not
Huh?
CGC, Central Government Council.
Central Government Council appears on behalf of the respondent numbers 1, 2, and 3. The petitioner herein have assailed the sentence dated 1/9/2021, whereby the petitioner was dismissed from service, as well as the grievance order dated 2/12/2021, whereby the petitioner's appeal was dismissed. Full stop. The facts of the present case shows the facts as enumerated in the pleadings reveals that the petitioner was appointed as in the post of rifleman, general duty, 25 Assam Rifles, with effect from 1/8/2005, and was allotted service number G/5009135 X R/GD. The petitioner was relieved on 20 February 2020 with 30 days EL earned leave. And was required to report at the unit Churachandpur, Manipur on 02/04/2020. It is the case of the petitioner that on account of the COVID pandemic, he approached the respondent authorities requesting him to grant 5 days earned leave. The office of the commandant, 22nd Assam Rifles, by the leave certificate dated 6/6/2020, granted 5 days earned leave with effect from 7/6/2020 to 11/6/2020. Admittedly, the petitioner did not join on 11/6/2020, but reported at the quarantine center Diffu on 5/10/2020. In the meantime, on 16/7/2020, the office of the commandant, 25 Assam Rifles, convened a court of inquiry to collect the evidence in respect to the circumstances under which the petitioner failed to rejoin on expiry of his leave and still remained absent without any information of the authority. The record reveals that subsequent thereto, a court of inquiry oblique board of officers, a court of inquiry assembled on 30/9/2020 in respect to in respect to collection of evidence in respect to collection of evidence relating to circumstances under which the petitioner proceeded on a 5 days earned leave with effect from 7-11 June 2020 and failed to rejoin on expiry of the said leave and still absented without any information of the authority. The said court of inquiry subsequently set again on 4/11
4-1.
huh?
4-1.
4/1
Yes, 4-1.
4/1/2021 and recorded the evidence and on 16/1/2021 a tentative charge sheet was forwarded to the petitioner, which was duly received by the petitioner on 16/1/2021 itself. The charge which was leveled in the said tentative charge sheet was in connection with Section 26, small b, of the Assam Rifles Act 2006, for short referred to as the Act of 2006, alleging inter alia that the petitioner, without sufficient cause, overstaying the leave granted to him, thereupon the summary of evidence was recorded in presence of, thereupon the commandant of the 25th Assam Rifles, acting in the capacity of the as a petty Assam Rifles Court,
No. Summary as well.
summary Assam Rifles Court, initiated those proceedings where evidence were recorded in presence of the petitioner. And the petitioner, who was standing in the capacity of an accused, neither adduced any evidence nor cross-examined the prosecution witnesses. At this stage, it is very vital to take note of that after the summary of after the tentative charge sheet dated 16/1/2021 was furnished to the petitioner, the petitioner was informed that the petitioner would be tried by the Assam Rifles, tried by Summary Assam Rifles Court under the Act of 2006 in relation to, in connection with, in respect to the charges, in respect to offense committed under Section 26B on 12/6/2021. This aspect is very vital, taking into account the submissions so made by the petitioner, as would be apparent in the subsequent stages of the instant judgment. The trial which was commenced and the charge being read out to the petitioner during the process of arraignment, the petitioner pleaded guilty. It is further seen from the proceedings which is enclosed as Annexure P to the writ petition that the petitioner was granted various opportunities but the petitioner instead pleaded guilty and accordingly he was convicted of the offense under section 26B. And a sentence was passed that the petitioner be dismissed from service. And the sentence was passed on 1st of September 2021 that the petitioner be dismissed from service. The petitioner was also informed by another communication dated 1st of September 2021, bracket Annexure S to the writ petition, that he can file an appeal, he can submit an application, a petition to the central government, the Director General, Assam Rifles, or any officer superior in command to the officer who held the summary Assam Rifles Court against the sentence imposed upon him by the summary Assam Rifles Court. The petitioner thereupon submitted a petition to the Inspector General Assam Rifles on 15/9/2021 which, however, was rejected by an order dated 2/12/2021. Assigning the reason that the petitioner was a perpetual defaulter and was awarded punishments on various occasions. Additionally, the petitioner was given ample opportunity to defend himself. The petitioner subsequent thereto, on 22nd of May 2024, submitted another petition to the law officer headquarters.
Received this application was submitted, received the MPO notice 2nd December 2021. This was not served to the petitioner in time. So the petitioner by this letter has requested for the decision of appellate appeal.
Huh?
By this letter dated 22nd May 2024, annexure U.
Yes.
The petitioner is requested to take a decision on his appeal. This immune order dated 2nd December 2021. It was furnished to the petitioner only on 16 August 2024. By annexure D, page 77. Only by this letter the immune order was furnished to the petitioner.
The petitioner states, the petitioner states that a grievance order dated 2nd of December 2021 was furnished to the petitioner only in the year 2024.
16 August 20.
16th?
August.
On 16th August 2024. No, that is different. I'm not on that. You submitted another communication on 22nd of May, nah?
By this 22nd May, the petitioner has requested the authority to furnish him the decision taken on.
Good stop. It is very relevant hearing to mention. It is also important, appropriate hearing to mention that the grievance order dated 2/12/2021 was not furnished to the petitioner till 16th of August 2024. It is under such circumstances that the petitioner, after awaiting, the petitioner was compelled to submit a representation on 22/5/2024 to the law officer inquiring as regards the delay in disposal of the petition so submitted by the appeal so submitted by the petitioner on 15/9/2021. The record reveals that pursuant to filing of the instant petition, this court had issued notice on 12/12/2024. The respondents 1, 2, and 3 had filed the affidavit in opposition. Well, let me come back. It's 1 o'clock, no? A bit possible.
Because for indulgence lordship, item number 7, here is a criminal appeal. So I've been appointed as an amicus curiae. However, we have not received the paper book till date, lordship. So we have inquired from the registry. It's ready, it says. So if this matter can be listed after a week, lordship.
We'll see when the matter reaches. And now, after you are here.
Lordship, I have some domestic problems to attend to, lordship.
Okay. Appeal I can dismiss for default. Don't worry. Let me take up first the ownership matter.
For admission, item number 1.
May Lordship.
Yes, what is it?
Lordship, I'm appearing for the petitioner, Lordship.
Hmm.
Yesterday only we have received copy of the affidavit in opposition filed by the respondent, Lordship. And they have raised some objection, Lordship. Therefore, I may be given 2 weeks time to file the rejoinder, Lordship.
The counsel appearing on behalf of the petitioner submits that in view of the affidavit in opposition filed on 26/8/2025, and he have been provided a copy recently, he would obtain instructions as to whether the petitioner would like to file an affidavit in reply. And thereupon, if necessary, file the same. List the matter again on. Can we have it on 25th of September?
Okay, Lordship.
List the matter on 25th of September. In the meantime, the petitioner is given the liberty to file the affidavit on or before 22nd of September. 22nd, you have to file your affidavit in reply.
Lordship. Obliged.
Rahim, I'm allowed to take one more problem. See, I said, taken in my writ petition also, the petitioner was charged under section 26. If you see that section 26. The penalty of dismissal from service not attracted under section 26.
Huh?
The penalty of dismissal from service is not attracted under section 26. If you see section 26 clause G.
Clause Z says, without leave from his superior officer or without due cause, absence himself from any school when duly ordered to attend there, shall on conviction by an ayah shall be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as in the act mentioned. So you want to go to the jail? No, I'm asking. I think imprisonment for 3 years is more punitive.
More serious. Section 26, assuming deal by a bench of this court also. This is paragraph 89. In this case, also the petition was filed by the somewhere else in my book.
How is this relevant?
I mean, no, para 15.
Huh?
Para 15.
Para 15, what does it say? This was a case where initially there was one proceedings. Thereafter, there was another proceedings.
Second trial.
The second proceedings was set aside by exercising powers under 137 or 96. Was exercised by the powers under 137. But there was not 136, the power has been exercised, and it was set aside without any reasons. And therefore, the court held that the second proceedings having been set aside, as regards the first proceedings have been set aside. On the second proceedings, there cannot be a second proceeding for merely on technical reasons. So how does it help you? Mr. Full stop. Petitioner case to full stop. The respondents, number 1, 2, and 3, have filed an affidavit in opposition, wherein at paragraph number 3, details were given as regards 3 and 4. Details were given as regards the unauthorized absence of the petitioner. Further to that, the respondents have also stated that the petitioner was given due opportunity in the summary Assam Rifles Court. And in spite of due opportunity, the petitioner neither availed those opportunities nor cross-examined the witnesses. On the other hand, the petitioner had pleaded guilty. It was further stated that the petitioner was a habitual offender, defaulter, and overstayed his leave willfully, as would appear from the details as given in the grievance order dated 2/12/2021. On the question of jurisdiction of the commandant to impose the penalty, impose on the question of jurisdiction. No. So it was further stated that the punishment so meted out to the petitioner was in terms with section 57(1)(c) of the Act of 2006. Which was permissible as per the provisions of the Act of 2006. Reference was also made to section 96 of the Act of 2006, whereby the summary Assam Rifles Court has the jurisdiction to pass a sentence of dismissal from service. Have you filed affidavit in reply? No. In the backdrop of the above, let this court now deal with, take note of the respectful, the submissions so made by the learned counsels appearing on behalf of the parties. It's paragraph only. Contentions of the learned counsel for the parties headlines. Mr. So-and-so, Lima Wapong, the learned counsel appearing on behalf of the petitioner submitted that section 11 of the Act of 2006 empowers an officer not below the rank of the Deputy Inspector General to impose punishment empowers the so-and-so to dismiss or remove from service any person under his command other than an officer or subordinate officer of such rank or ranks as may be prescribed. The learned counsel for the petitioner therefore submits that a commandant could not have dismissed the petitioner from service in view of the stipulations contained in section 11 of the Act of 2006. In that regard, the learned counsel referred to the judgment of a coordinate bench in the case of NO.G/3900550, RFN/GD Govind Singh Bathel BATHYAL versus Union of India and others. Reported in 2014 3 GLT (ML 228 and submitted that a similar issue was decided following another judgment of a coordinate bench of this court, which was approved, confirmed and approved by not only the learned division bench of this court, but also the Supreme Court. Reference in that regard was placed upon paragraph number 6 to 8 of the said judgment. 6 to 9 of the said judgment. The learned counsel further referred to another order passed by this court, by another coordinate bench of this court, in the case of Sri Maulong, another judgment and order dated 29/7/2015. In the case of Sri Maulong versus Union of India and others, bracket WPC number 3K/2015, wherein a similar issue have been decided. Per contra, Mr. Yangavati, the learned CGC, submitted that this is not a case of disciplinary proceedings. This is a case where, on the basis of an offense committed by the petitioner under section 26B of the Act of 2006, a summary Assam Rifles Court had inflicted punishment in terms with section 57 bracket 1 bracket C small c of the Act of 2006. He further submitted that the said order, the said punishment so imposed by the summary Assam Rifles Court even do not require any confirmation. And has to be carried out forthwith in terms with section 136, bracket 1 of the Act of 2006. Distinguishing the judgments referred to by the learned counsel appearing on behalf of the petitioner, Mr. Yangavati, the learned CGC, submitted that in those judgments, the learned court bench did not take into consideration section 57 as well as the power of the summary Assam Rifles Court to inflict punishment. And as such, the said judgments are not applicable to the facts of the present case. Mr. Diok, analysis and determination. From the facts as above narrated, it is apparently clear that the petitioner had overstayed his leave granted to him, inasmuch as the petitioner was supposed to, the petitioner ought to have joined his service on (12/6/2020), but he joined only on 5/10/2020. First, a perusal of Annexure M to the writ petition clearly reveals that the petitioner was duly informed that a perusal of Annexure L to the writ petition reveals that the petitioner was charge sheeted in terms with section 26B of the Act of 2006. It is further very pertinent to take note of that by Annexure M to the writ petition, the petitioner was duly informed that the offense against which the petitioner had been charge sheeted would be tried by the summary Assam Rifles Court. First, the records of the Assam Rifles Court, a summary Assam Rifles Court, have been enclosed as Annexure P to the writ petition. First, a perusal of the said enclosure clearly would show that the petitioner was duly given adequate opportunity to defend himself. First, the petitioner not only did not, the petitioner neither adduce any evidence or cross-examine the plaintiff, the prosecution witnesses, but also neither adduced any evidence nor cross-examined the prosecution witnesses. First,
And also he has pleaded guilty.
let me write. That is my finding. First. On the other hand, the petitioner had pleaded guilty. Under such circumstances, it cannot be termed that there was any infraction to the procedure by the summary Assam Rifles Court. The petitioner thereupon was imposed with a penalty, a punishment, for the offense committed by him under Section 26B of the Act of 2006 of dismissal from service. First. A perusal of Section 57 as well as Section 96 of the Act, and a conjoint reading of Section 57 read with Section 96 of the Act of 2006 would show that the summary Assam Rifles Court has the jurisdiction to inflict punishment for dismissal from service. First. This court further finds it relevant to take note of that the appeal which had been, the representation which was submitted by the petitioner on 5/9/2021 was disposed of by the grievance order dated 2/12/2021, whereby the authority above, the officer who held the summary Assam Rifles Court, had further justified that the infliction of the punishment under Section 57(1)(c) was justified as the petitioner was a perpetual defaulter. First, the above aspect, the above finding, above materials on record do not justify, in the opinion of this court, do not justify any interference, taking into account that the respondent authorities have followed the mandate of the Act of 2006, and there seems to be no infraction to the proceedings, to the procedure which was required to be followed. First, in addition to this court also finds it very relevant to observe that the petitioner is in the disciplined is employed in a disciplined service, and a default and defaults as have been committed on a habitual basis cannot be a ground, does not inspire this court to exercise its jurisdiction under Article 2 to 6 of the Constitution. Consequently, this court does not find any merit তাৰ আগতে এটা লেন লিখি দিব বুঝতো এই তাৰ আগতে before parting with the record তাৰ পিছত consequently before this court before parting with the record finds it relevant to observe that the judgments referred to by the learned counsel appearing on behalf of the petitioner are judgments pertaining to disciplinary proceedings and have no reference in respect to inflicting a punishment by the summary Assam Rifles Court under Section 57 of the Act of 2006. And as such, the said judgments, with due respect, would not be applicable to the facts of the instant case. Next. Considering the above, this court doesn't find merit in the instant petition for which the petition stands dismissed. However, in the facts of the case, this court is not inclined to impose costs.
Your Worship, the petitioner will be kindly allowed to submit a second appeal under section 139.
এতিয়া এইটো গুচাই দিব এইটো I remove that portion. Discipline service, I remove it. Okay. Mr. Before parting with the হেতুত আহিলে তাৰ আগৰ এটা যে দেখিছিল discipline service this court does not want. Mr. Pursuant to the at the time of at the conclusion of the dictation of the judgment in the open court, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the petitioner may be given an additional opportunity to submit a representation on the proportionality of the punishment. Thereby drawing reference to section 140 139(2) of the Act of 2006. It is observed that if the petitioner, it is observed that the petitioner is at liberty to do so. And the observations made in the instant petition shall not affect the concerned respondent authorities in deciding the said representation.
The petition will be allowed to submit a representation within a period of 2 weeks. And the opportunity will be direct to dispose of the same within the time frame.
Absolutely no.
In the earlier occasion also, by representation we have submitted in the year 2001. It was communicated to me only in the year
You are at liberty to submit, you submit, and if nothing is done, then you are here, I am here, come here. Because you see, you have not submitted. How can I impose a time? There are many cases which I find there also. They said, we'll submit a representation, they should be disposed. Whether you submit or not, how do I know? Why should I say on things which is yet to happen?
Yet to be submitted.
I'm giving you a liberty.
Obliged to.
For admission, item number 5.
Your Lordship, the respondents, what are respondents? We have not received any instructions. So give us some time.
What is the matter about? So many persons.
The instant matter pertains to illegal occupation of the land of the petitioners by the Assam Rifles Lordship.
By?
Assam Rifles Law.
Oh, yesterday time matter.
Similar matter.
That day, yesterday matter, I felt sorry for that lady advocate. I didn't put that order. I said it listed on 15(9) for instructions from the respondents. So here also I'll put this matter on 15(9).
Obliged.
But that lawyer, she would have got a very good order. But as I have done the same thing there, I should not do here. a long time old order. List this matter on 15/9/2025, on which date the respondent shall ensure that the instructions are placed before this court, on the basis of which the respondents are occupying the land of the petitioner. The respondents are occupying, are purportedly, are said to have been occupying the land of the petitioners.
Obliged. For admission, item number 6.
May I please allow him?
Yes.
Lordship, I'm yet to find out, should I? I'm yet to receive
Compassionate
instructions.
appointment.
Yes,
my lord.
When your father expired 17 years ago.
No, my lord.
How many years?
Yes, sir, for 17 years.
And then he expired when?
13 for 2024.
13/4/2024.
Yes, my lord.
Then they have a particular office memorandum. As per the office memorandum, they put it in a particular serial number.
yes, Lordship.
Now, what is his serial number?
Lordship, I'm yet to receive instructions, Lordship.
Tomorrow? Instruction only. What is his serial number? Matters.
Lordship, if it can be listed.
Monday?
Listed, Lordship.
Monday?
Lordship.
It's only in instruction.
Yes,
What
sir.
is the petitioner's serial number?
Yes.
That's all. And if the petitioner is in the serial number, he is also happy. And if he is happy,
Yes,
his client is also happy. Isn't it?
Yes.
Ms. Soensar, Ms. S. Young,
Yes, Lord.
appearing on behalf of the respondent, submits that she would obtain instructions as to whether the petitioner's case is under consideration of the respondent before the respondent authorities for appointment on compassionate basis. List the matter on Monday 1/9.
Deeply obliged, my lord.
From the supplementary cost list for admission, item number 13.
Lordship, I beg to mention on behalf of Indeed Song Additional Age Lordship.
Who?
Indeed Song Additional Age Lordship. If this matter can be passed over for the day, Lordship, since he has some personal work.
Who?
Indeed Song Additional Age Lordship.
What has happened?
He had to attend some.
What is the matter about?
Lordship, I'm praying for.
Disability pension and pensionary benefits. Affidavit filed.
Yes, yes, my lord.
Why you have not been given?
Lordship, no reason. They only say that I am not entitled for invalid pension.
Invalid pension and disability pensions are two aspects.
They have said that in the India affidavit.
Okay, let us have it in the presence of Mr. Imtim Song. When is he available?
Tomorrow, Lordship, if it can be passed over for the day, Lordship.
Lordship, may this.
He has difficulty on Friday, isn't it?
Lordship, I can make it.
No, you
But
said
the only prayer.
that day you said you have difficulty on Thursdays, Fridays.
No, Lordship, that was.
Then also I said that, okay, it's a case of pension, don't worry, I will take care of you.
Lordship, the only prayer that I want to make is that make it as a fixed item in
When do you want it?
tomorrow. Right now.
Lordship.
Is the matter tomorrow? Taking into account the inconvenience have been taking into account the inconvenience. Taking into account that the respondents are Mr. Imtim Song, the learned additional AG, is a learned additional AG is not available today.
Lordship, right.
For admission, item number 14.
May I please, my lords?
Yes.
My lords, there are three issues, at least three issues which arise in this case, my lords. The first issue is, my lords, decided by my lords, sitting at, my lords, the Gauhati bench. The notification 56, my lords, have already quashed that notification. My case is squarely covered, my lords. I may give 3 dates to my lords. My lords, by way of notification number 56, my lords, the period was extended for 1 month. So assessment which was to be made by 31/3/23, the date was extended till, my lords, 30th of April 23. That notification, my lords, quashed, saying that there is no approval of the GST Council, there is no recommendation rather. My case squarely falls, my lord. The order in my case is dated 30th of April 23, and the show cause, my lords, is dated 31st of January 23, which can only be saved by that notification and nothing else. That is the first leg, my lords. The second is, my lords, my lord, challenged several notifications. My lord, what the government did was, initially they did not come out with a form by which returns were to be filed. In fact, my lords, I had the privilege of presenting this in Guwahati High Court before my lords, but at that stage, my lords found it fit to send it to division bench, and then division bench has decided that case because later government itself changed the law. So government brought about a retrospective amendment. Section 16(4) was, my lords, improvised by way of 16(5) by way of a retrospective amendment. In my own cases, there are 3 orders of this honorable court, including division bench at Kohima itself. That is second aspect, but my lords, my case would be squarely covered by the first aspect itself. Third is, my lord, no hearing has been given, nothing. My lords, that part I need not therefore argue at this stage.
But Mr. Agarwal, the question is,
Yes,
I told that after my judgment,
yes, my lord.
the judgment of the Patna High Court, whereby it went into the taxation, extension of taxation time and all, that is the one thing. Then you have a judgment from Telangana. Then you have a judgment from Kerala. All this now is pending before Justice Partiwala.
That's right, my lord. My lord, I can't shy away from that. The only thing is, my lords, in the state
We
today,
do
my lords,
let us have this matter after some days.
my lord, if I may suggest, my lords, if subject to what my lords find appropriate, my friend, my lords, is carrying a compilation, my lords, that because in that case, my lord, my case is squarely covered by my own orders, my lord, by this honorable court on 16(5) issue, where government has itself, my lords, extended the time for claiming the credit, and this honorable court, my lords, has been asking us to.
No, the benefit which is there.
That's right, my lord.
Are you, therefore, the question is whether your case is covered under the 2024
That's right.
Act.
I'm sorry, my lord, the last word, my lord.
Is your case covered under the 2024 Finance Act?
Yes, squarely, my lord. Squarely.
So then why do you need to go to 56 then? If you come
My lord, because some small little issues would still remain. And in any case, then if my lords were to hold that the proceedings are honest, then my lord, it's fine. So my lords, if my lords find it appropriate, my lords may pass similar order.
No, Mr. Agarwal, why I'm saying so?
Yes.
Also, some coordinate benches pass orders being passed where the question did not go into the question. There are a lot of people who are a lot of petitioners who were before me,
Yes.
where they say that we are not concerned with all the 56 and all. Our case comes squarely covered by the Finance Act of 2024. And
my lord, I understand what is falling from my lords. To that, the answer is, my lords, there are 2 other issues also apart from the 2024 amendment, my lord. If my lords were to hold that, it is time barred because of that, because of 56. Then my lords, everything goes.
Then we do one thing.
Yes, my lord.
I'm told in the Supreme Court, written arguments have also been filed. Let's
All right.
put this matter on 3rd of November. And
Yes,
then we extend the interim order.
All right, my lord. That would be fine, my lord. One thing, my lord, they have not filed a counter for an year, my lord. If they want to, my lord, they may file. Or let it be closed.
Question of filing counter does not arise.
Then that may be recorded, my lord, because they keep on saying.
We are concerned with the order passed on a quasi-judicial side.
That's right, my lord. So your my lords are right. And my lord, I should be fair in also pointing out one aspect that, my lords, in this case, what has happened is the order was served on us after the limitation period had ended. And if my lords would like to just have it, I don't know whether my lords has the GST Act there, because my lords, if my lord would be able to see that, my lord? Or should I read it, my lords?
You're referring to 172?
I am referring to 7310, my lords.
Okay. 7310.
Yes, my lord. May I read, my lord?
It's okay. I remember that.
My lord, what it says, what I wish to point out there is that there is a time limit given. Assuming 56 time limit also, they served it after that. So that anyways it is time barred. That's my lord's another submission.
But that is a question on the question of limitation. That is a
That's right.
Whether if you file an appeal, you are prejudiced to that effect.
That's right, my lords. Because I have challenged the notification, I had no option but to come to this one.
Otherwise, we do have this matter again on 3rd of September, November.
Yes, yes. Yes,
And
yes.
the account that the matter is pending before the Supreme Court on the issue of
Oh.
legality and validity of 56.
Yes, my lords. And my lords would also like to, my lords, record that there are other issues also, including 16.5.
Ah, okay.
Yes, my lord.
It has been submitted by Mr.
Puneet Agarwal, my lords.
Puneet Agarwal, the learned counsel appearing on behalf of the petitioner, that the present with petition challenges the notification number 56 oblique 2023.
Yes, my lord. Yes. Yes.
23, date 23, which has been a subject matter of which is presently the legality of which is also presently pending before the Supreme Court. In addition to that, Mr. Agarwal has also submitted that there are other issues which are also other issues as regards the application of the amended 16.5
Grateful. Grateful. Yes.
of the Central GST Act, GST Act 2017. And as such, he submits that it would be in the interest of justice, the matter be postponed to be on some another date, taking into account that the Supreme Court is in session of the matter. This court, having heard the learned counsel and have also perusing the materials on record, is of the opinion that it would be in the interest of justice that the decision of the Supreme Court in respect to the legality and validity of the notification dated 56/2023 be awaited. First of list this matter on 3rd of November 2025. The interim order passed earlier shall continue till then.
My lords, may just put a date a week after that, my lords.
Okay, because here the winters are becoming more severe, but that goes further.
All right, my lords. Third, I have some
You'll-
difficulty, my lords. I'm traveling on third.
You'll be appearing from the luxury from Calcutta?
I am from Delhi, my lords. I'm
Okay,
extremely
from
grateful,
Delhi.
my lords.
So Delhi, it will be good, then it will be on, let's have it on 10th,
I'm grateful, my lords. That would be fine.
10th of November. Interim.
Extremely grateful, my lords. And interim may be continued, my lords.
I've said that interim shall continue.
Grateful, my lords. Grateful. It's a privilege, my lords. Grateful.
Orders, item number 7.
What is this criminal appeal? Oh, you want time? Appeal is admitted. Oh, I admitted it. Why the matter has come up before me?
Lordship, that's why.
I admitted 1 year back. Now it has come up. A person is inside. Is the person inside?
Yes, madam.
What has happened?
By senior Ajo, he is a legal aid counsel.
376 of the Indian. Legal aid counsel is okay. If he's not available, then we should go ahead.
In fact,
Can be penalized under section 4 of EM. Now, what is this?
POCSO case, madam.
Why the matter has come up after such a long time?
Lordship, in fact, there was a direction to prepare a paper book.
Oh, nobody has paid. But this is done by the legal services, na?
Yes, and I'm the.
Okay, then I think the payment of the paper book has not been given, so it has not been given. So we direct the district, the state legal service authority to bear the expenses for the copies. This court have duly taken note of the office note dated 26/8/2025, as well as the submission of Mr. N. Mujoy, the learned counsel appearing on behalf of learned amicus, who submits that he has yet to receive the paper book.
Yes.
So, taking into account that this is an appeal, it's a jail appeal,
Yes.
and jail appeal, this court directs the Nagaland State Legal Services Authority to defray the cost of the paper book. Full stop. Who is appearing for Nagaland State Legal Services Authority? Yes, madam can appear, Mr. Kroy. You can tell those people, na? You are the additional advocate general. Miss V. Sukroi, the learned additional advocate general, shall intimate the Nagaland State Legal Service Authority to do the needful at the earliest and preferably within a month time, taking into account that the appellant is in
Undergoing imprisonment in central jail.
Is serving his sentence.
is serving his sentence. First, list this matter again on on 25th of September 2025. Full stop. In the meantime, this court further directs the registry to furnish copies of the paper book to the learned counsels who represents the parties so that the appeal can be taken up for disposal at the earliest.
My lord, I pray that my senior is in amicus curiae, so that may be reflected after his name in the course this one. Appealant, counsel for it.
You know what to do. I'm not going to say anything to you.
Last please.
For orders, item number 8.
Grocery shop and bank business petitioner is not represented. Yes. Why the matters come? Wakalatnama filed, so return service, Wakalatnama filed. Why the matters come up for orders? Everybody represented? Service complete? Yes. Oh, your account is frozen still now. You have no urgency. You have? You want to do the matter or not? Then should we, who is appearing for the bank? You are appearing for respondent. Who is the person? Where's the petition? This is the. You are the respondent. You have frozen the bank account. Why?
Because we have received instruction from the Director General of Police.
You have filed your affidavit.
Lordship.
What do you say?
Your Lordship, when the matter was taken up on 22/05/2025, this court observed that the Director General of Police should also be included as a part of respondent. Accordingly, they have also taken steps.
Police.
Lordship,
You have done at the instance of the police.
Lordship, yes.
And police who is appearing? Police have not been made a party. Notice
Yes,
have been
or-
issued upon respondent number 2 is awaited. Who is the respondent number 2?
Cybercrime.
Huh?
Director General of Police, Cybercrime CID.
Why you are making the Director General of Police cybercrime? A grocery shop, what business do they have? Cybercrime. You are indulging in cybercrime. Yes, state who is appearing? Some state has to appear. Somebody amended cause title file, so state has to appear. Who is the amended cause title? Let us see. Director General of Police, as a result, the bank account have been seized. Heard so and so submitted by Mohammed and yeah. Sure. Yes, madam, somebody has to appear. They cannot, it is the office, Director General.
It's the state of Gujarat.
Huh?
Director General of Police, Cybercrime, Gujarat.
Gujarat?
Yes.
Oh, why? They have insisted. And the service is complete? No. Oh. This cannot happen like this, no? Anyways, you have not been able to serve.
We have served the copy. However, service of notice still awaited.
You don't have urgency. Open a bank account different. Open a different bank account if this is the state of affairs. The service upon the respond number 2 is awaited. List the matter after completion of service.
Lordship, if I may be allowed to send a fresh notice to register.
The petitioner is given the liberty to take fresh steps by way of registered post upon the respondent number 2. List the matter after completion of service.
For orders, item number 9.
Selection and appointment to the horticulture department. Yes.
Lordship, appearing on behalf of my senior, Zechimon.
What happened? She was very much here. Where she's gone?
Due to some unavoidable
Seeing that it is
circumstances.
for orders, so why should we be there? We are senior lawyers. Is it something like that? Then, where is she?
Some circumstances she is
Service upon the respond number 5 being not complete list the matter of the completion of service.
blood rush.
For orders, item number 10.
May I please, Your Lordship,
What is this I for?
for deletion of 2 petitioners, that is petitioner number 31 and 36.
Why?
Petitioner number 31, as of now, don't want to pursue the matter, and then 36 is been regularized. That is the grounds.
31 is fed up
Lordship.
and 36 has been regularized.
Lordship.
Check. This is an application filed on behalf of the petitioner number 31 and petitioner number 36 for deletion of the name from the accompanying writ petition in view of the fact that both the petitioners do not want to further pursue the present proceedings. Ms. A. Amy, the learned counsel appearing on behalf of the respondent, submits that she has no objections. Taking into account the above, the names of the respondent number 31, petition number 31 and 36 are accordingly struck off from the accompanying writ petition. Full stop. The registry, full stop. Registry shall duly take note of the said aspect, and the petitioner, the counsel for the petitioner herein is directed to rearrange the petitioners in view of striking out of the petition number 31 and 36 and file a fresh memo of parties before the registry of this court, and the registry on the basis thereof, as well as the present order, make necessary changes in the cause title and update the same in the CIS. The memo of parties be filed within 7 days. I stands disposed.
From the supplementary cost list for orders, item number 15.
Next, Lordship. Lordship, with respect of the IA,
Yes, what is this matter?
IA 115, Lordship, I may be allowed to withdraw with a liberty to file a fresh Lordship. I
What
have.
is this IA business? What is this matter going on?
Lords, can I just explain what the matter is?
Yes.
Lords, here is a case where a child, newborn child, she suffered asphyxia in the hands of the hospital, and since then she is in a vegetative state, and she is on the ventilator support in the hospital. Oh, here is a rate, my lords, where actually the parents of the child, they are seeking the continuous treatment and fixing of the responsibility of the persons who are responsible for the medical condition of the child. Lords, on the last date, my lords, this honorable court
This application 155
Lordship.
will filed by the hospital, my lords.
For the hospital, Lordship.
You want to withdraw this? Huh?
Lordship, and file a fresh Lordship. There's become some error in the application, so I may be allowed to add a withdraw and a file.
Mr.
Rectifying the-
Ponte, the learned counsel appearing on behalf of the applicant submits that he may be permitted to withdraw the instant application in view of certain formal defects and may be permitted to refile by removing those defects. Taking into account the above, the instant application stands closed on withdrawal, liberty given to the petitioner to refile by removing those formal defects.
Then, my lords, may kindly have the order passed by this honorable court on the previous date, where a judicial inquiry was ordered. The lordship can have the order of 17th of July in IA 65.
What is that? I 65.
Yes, my lords.
No, 60, 85.
65, my lords.
85, is it? We have an 85.
Lords can have the order of the last date. So there are two orders. One is running into 3 pages, and the another order is of 7 pages. So I'm referring to the order which is running into 7 pages.
Huh? There's 65.
Yes, ma'am.
What is this?
Your lordship have got the order, my lords?
Yes, when Sachin Jain, the learned
Yes, my lord.
heard here. In time, application has been filed by them seeking a direction for a thorough investigation into alleged misconduct and criminal act of forgery by the former AUMA. We said to have filed an interlocutory application without their consent and authority, resulting in deletion of our relief demand sought for in the application. The applicant alleged that the signature was forged not only of the petitioner, but also of the learned advocate stationed at Delhi by the respondent number 7. She tempered the Wakalatnama and sought for modification of demand. Is a report submitted?
Lords, please have para number 7 of this order. There, the specific directions are also.
Is the report?
Lords, we are not informed about it because it was supposed to be in the closed envelope.
What relief you want to withdraw? Was withdrawn?
Lords, in fact, my lords, the earliest, the erstwhile council, she has withdrawn all the prayers that I had made in my writ petition.
Ah.
So if your lordship will have para 7 of this order,
When was it withdrawn?
lords, my lords, 10th of March 2022.
10th of
March 2022. My lords.
What is the relief which have been withdrawn?
Yes, my lords. My lords can have the main writ petition. If your lordship can have the main writ petition, please have page 83.
Mr. Counsel, let me make
Yes,
it.
my lord.
This was a matter, I last time when the matter came up before me, I had given a very strict, I remember this matter very well. When the matter was moved before me in the month of February 2022, I inquired with the learned counsel who was appearing then, Miss D. Ghosh. I asked her that, are you going to insist? Because if you insist on those prayers, I am not going to pass these orders. Then it is under that circumstances she had submitted. If you keep on insisting this, Mr. Counsel, I make it very clear. If you keep on insisting this and try to penalize some of the advocates unnecessarily, then obviously this is a thing which have been done by this court. Pursuant thereto, Mr. Jain, kindly understand. Pursuant thereto, the baby out here was airlifted to Delhi. Pursuant, there are two orders.
No, my lord.
So this, she was airlifted to Delhi.
No, my lord. Not in this case.
No, I don't believe.
It was not airlifted.
Which one this? Yes, this is the case.
But the view was not elected to Delhi.
Okay, but there was
Because
a direction
only-
passed by Justice Chaudhary.
Yes, yes.
I remember this because my bench was changed. I who had passed these initial two orders on 873 and 83. Thereafter, the order was passed by. There may be some other order being passed.
No, this is a different matter, I think.
On 15 days, an order passed by Justice Chaudhary. This is not a different case. I remember this case.
Not in this case, there was no airlifting of the child as.
Anyways, the baby, here there was a question out here that the baby could not be given treatment out here, taking into account that there were no further facilities available with Christian hospital. And they were asking the baby to be taken away. So that as the petitioners hearing did not make any payment or anything, any payment was made. I passed an order that kindly keep the baby, the payment we will consider later on, by which we can ask the state, or taking into account that the Christian hospital is standing on a land belonging, which was donated, which was given by. Therefore, we will take into account in view of the judgment of the Supreme Court in that case, that the Mulchan case.
Yes, my lord.
So that was the issue involved there. If you have any problems, you go and file in the consumer forum.
Lord,
No, Mr. Counsel, these have nothing to do out there. It is upon this court had made it very clear at that point of time not to insist on that. Kindly go and file it before the consumer forum. We will dismiss the petition.
now, my lord, may I make my submission?
Upon this, I'm going to dismiss the petition right away.
No, my lord, may I make.
Mr. Counsel, you have to take note of when the court passes an order at that point of time. If you see my earlier order passed on 2022, then I that though there are various allegations made in the petition here, the learned counsel for the petitioner submits that she is not pressing for the receipt sought in the year and would file appropriate application for deletion of the name. However, the only grievance in the case is the baby who is presently suffering from this particular disease.
So that's the only child is the only concern, nothing else, my lord. Because the
Therefore, if you want to extend this thing unnecessarily, I think
no, my lord. No, not at all.
Lord,
can I just make
counsel? I am not going to hear anything to that effect. Last time when the matter.
I am not submitting on that.
In the month of April, I told you that don't insist this type of things. When I came, but again you are trying to insist upon this. I think this thing has been duly taken care of with this Mr. petition. Right away, go ahead. Go to the Supreme Court, wherever you want.
No, my lords. Now, can I make my submission?
No, nothing doing, Mr.
No,
Counsel.
my lords may not agree.
Your clients have taken an advantage. I have given all the reliefs which was necessary for the baby. If you have any claims, go ahead and take a claim as regards that. We will amend it, but don't blame the advocate for that. I'm telling you. The advocate had, and at that point of time, you see, you are asking about this particular advocate. The earlier advocate who was appearing on that day was another advocate who said that she is going to file that application.
My lords, can give me opportunity. Let me respond to that. If your lordship feels satisfied.
Mr. Jain, tomorrow you may face a similar situation.
I know, my lord. I know.
Tomorrow, if a matter comes before me or before any other court and the court insists that I'm going to pass that, then you may make and give an undertaking to that effect that, okay, I'll file an appropriate application. But that is beside the point. You are fighting up this unnecessary aspect. Your basic thing is at that point of time, the child had to be taken care of. The Christian Medical College was thinking that we are going to ask them to leave. This is the basis on which we have taken care. And now you are taking up unnecessarily. If somebody does something good for you and this is what has been done.
Lords, no, not at all. Now, may I?
I'm not even looking into this inquiry.
First of all, this was the first time I am appearing before your lordship because so far as my memory goes.
And if you have any problem, go to the Bar Council, prove it. Why should this court go into these aspects?
Lords.
Mr. Jain, this is unfortunate.
Lords.
This is very unfortunate in this situation, and therefore, we will again consider this matter. And I ask you to advise your clients to do the needful. Don't insist on this application. I'm answering. You want to go ahead with your petition, you go ahead. You want this court to pass an order that I pass an order that you can pursue against Christian before the Consumer Forum. Go ahead. But not in this writ petition. I'm telling you, nothing to do in this writ petition.
Well, I'll talk to the client and I'll come back after 4 weeks. But the only thing is, I wanted to say something.
No, Mr. Jain, tomorrow. I'm saying it. Tomorrow we are having it. List the matter tomorrow. Get your instructions.
Well, then not tomorrow because tomorrow I'm not available. Tomorrow. Kindly appreciate I'm not available tomorrow.
If you are not available tomorrow, we'll dismiss for default.
But may hear it today.
Absolutely tomorrow.
Lord. May fix some time after 2 p.m. my lord?
Tomorrow, 2 p.m.
Fair. Thank
you.
You
are not, Mr. Jain, you are not out here physically. And if you cannot be present through a video conferencing, then God save you.
No, my matter is listed. It is listed.
Mr. Jain, I'm saying tomorrow at 2 p.m.
Yes, sir.
The matter tomorrow at 2 p.m.
Grateful, my lord. Grateful.
For hearing, item number 11.
Lordship.
Yes.
Your Lordship, my senior has some personal difficulties today. If this matter can be adjourned.
Who is your senior?
Jamir. He's attending.
He does so much of matters. That is why that is the problem. What is the matter? Dismissal from service. So you are happy if you are dismissed from service, that you don't want to do the matter.
Attending through BC, Principal C to Lordship.
Yes, madam, what is the case?
Commissioner, challenging the dismissal order.
You have dismissed on 2 grounds, criminal.
Yes, sir, on conviction of criminal.
Wrong.
Lordship.
No case. And criminal, how many years? Jail? Have you filed an appeal?
Yes, Lordship is pending.
So, and if it is on the ground of this, then I think you let the appeal be decided. You can't help it now. As of now, you are convicted. So therefore, it will happen on a later on. If this is the ground, then you take the judgment of that another case now. What is called recent judgment in 2024 given by Justice Vishwanathan. Look into that. I think Ramlal Yadav. I remember that. So Ramlal Yadav is a case by which the court has said that if it is exactly on the same facts and all, and then obviously if he is exonerated, he should also be done.
Lordship, here in this case, the disciplinary inquiry was not conducted. The dismissal order was passed without conducting.
Not necessary. 11,
Lordship.
Rule 11. So that is not necessary. So you want to remain dismissed? So we adjourn it for how many years? 4 years? 5 years?
Can be listed on Tuesday, Your Lordship.
No. Don't take it before me. I'll dismiss it. Huh? Today is a bad day. I've dismissed so many cases. List the matter. As inconvenience have been shown on behalf of Mr. Muazzamir, the learned counsel appearing on behalf of the petitioner. Matter stands adjourned to be listed after 2 weeks. Ms. So-and-so appears on behalf of the state response.
For hearing, item number 12.
Yes.
Your Lordship, I appear before your honorable court on behalf of the petitioner.
Petitioner.
Yes, sir.
Petitioner is this side, na? And you have come with small diary. So that means you are not going to do it. Petitioner counsel coming with a small diary.
My lord, I have taken the consent of the respondent's counsel and we want to adjourn our matter.
Why?
Therefore, my lord, I pray for your magnanimous aid and kindly adjourn our matter and to be listed after 3 weeks, my lord.
Land compensation. Chalo. The counsel appearing on behalf of the petitioner is not agreeable to do the matter when the matter is called. Consequently, the matter stands adjourned to be listed after 4 weeks. Ms. So-and-so appears on behalf of the respondent state. Finish.
Lordship, respondent number 2, 3, 6, and 7. NIGDCF.
So-and-so appears on behalf of the respondent number 2. So should I put it like this? The petitioner doesn't want to do the matter to be listed only after an application is filed. Huh? I think this is okay.
हमको बोलना चाहिए कि तो थोड़ा खत्म होने वाला Exactly. Okay. And this has come. On your opportunity.